Good morning, Perry. This is Ashton. This is another masterclass. Today we're going to talk about the situation with the buyers when the buyers pulling back or they change their mind or something happened, whether it's a house or a condo, as long as the property. So I invited our special guest Perry and Benipal to join us. He's a lawyer. Actually, he's working in the same office that I work in Oakville, and he has many years of experience. So I'm going to go through my very quick presentation, and then I'm going to open the microphone to talk to Perry. So as you all know, or some of you might know, all of the training material goes on my YouTube channel. There are more than 100 videos there, and these are details training. So if you have questions regarding Instagram, regarding prospecting, door knocking, anything you want should be there. So I suggest you to go there and just subscribe, because every single week I add new video there, and these are all training. On Monday at 8:30 to 9, we have accountability calls. These are agents from different brokerage, doesn't matter what. And we have role play from 9 to 9:30, and everybody is joining. We have our WhatsApp group for many agents. Originally started with door knockers, those people who are door knocking, and that it is for support and encourage one another. So just join, it's free. And today we are going to talk about the buyers decided to not close. Well, bad for them. So thank you very much, Perry, for joining us. And I am giving you the microphone here. Tell us very briefly what you do, your background, and then dive into the subject for today.
Are you watching this? What are you watching? Are you watching
Okay, well, good. Thank you very much, Ashton, for the introduction. Good morning, everybody. My name is Perry Benipal. I am a lawyer. I work at the law firm of Papazian Heisey Myers. We're located at York and King in downtown Toronto. I am a real estate lawyer and I do mortgage enforcement as well. I do a lot of the transactional work along with a lot of court work as well. So, as Ashton said, we're in a situation now where we're having buyers walk away. And today, my role is going to be to try and equip you with what you can know and how perhaps you can try to get a closing done. And if there's not a closing done, obviously, what you can tell your clients is going to be the next steps and how they can avoid pitfalls. I did prepare a presentation, so I'm going to just share my screen. Right, and we're just going to start from the beginning. Okay, so here we are in the presentation, and buyer decided not to close. As everybody knows, the market has shifted, and this is a very important topic. Just a quick introduction about me. Law firm I work with is Papazian Heisey Myers. We're located at 121 King Street, West Toronto. King and York is the intersection. Our firm work mostly involves insurance defense, bankruptcy, insolvency, and debt collection. My work involves power of sale transactions, real estate transactions, and real estate litigation. Our clients at our firm include National Bank of Canada, Canadian Mortgages, Inc., and we have other institutional clients as well. That's a little bit about me. In terms of the current market, I think it's, I think everybody will agree. It is on a decline and it has been on decline for quite some time now. The current issues we're facing is really, the appraisals. The appraisals not coming back. They're not matching the purchase price. We've had instances where we're litigating cases currently, and I have some case examples which I will share with everybody, where there's purchases that were purchased in June and the appraised value has gone lower. So, it is a shifting market. It's very hard to navigate. So we'll talk about those issues. A lot of things in around new build transactions. So as everybody knows, new build purchases 3, 4, sometimes up to 5 years ago. The closing date has now come. This is happening a lot in the condo market. The appraisals are just not hitting. And, builders are also faced with a dilemma here because naturally they have financial obligations and they have financial institutions which they need to answer for. It's a large issue at stake here. And I have a lot of clients that come to me to say, oh, Perry, well, the value of the property has dropped, so I simply cannot close. And, they may not like what I have to say to them, but I would say, well, if you did make a profit in this, would you share that with the builder? And obviously the answer is no, right? It is a changing market. Consumer confidence, I would say it's at an all-time low, and consumers are feeling the squeeze. Things are very tight, so you need to have the tools to be equipped with to answer the client questions and know what to do in this current market. So in terms of what can happen, so we'll just walk through a typical scenario. You have a purchaser purchased a property, let's say maybe 6 months ago, or if it's a new build transaction a couple of years ago. So they say, okay, Perry, well, I simply cannot close. I cannot get a mortgage. I don't know what to do. What is going to happen? That's a conversation I'm having daily these days. And I always start with, well, the forfeit of the deposit. It's well-established case law that the deposit is a promise to complete the transaction and is lost if you're unable to complete the transaction. Now, obviously, every case is different. Every case has its own facts, which we'll discuss later as well. But typically, in a black and white world, this is what happens. You forfeit the deposit. That's the first thing. In terms of other issues that can arise, there can be lawsuits. So the vendor, who is the seller, in addition to keeping the deposit, there can be a lawsuit where the vendor or the seller or a builder sometimes can sue. Typically, what they're suing for is the difference between what they sell the property to a third party to, so a third party bona fide purchaser, versus what they sold the property to the current buyer, plus any cost of the carrying cost of the property. So the carrying cost of the property could include the property taxes, the utilities, and the mortgage payments if they have to have any. So, we're going down that line. Client is in front of you saying, okay, I cannot close. What can happen? And these are the things. So forfeit of deposit, and there can be a lawsuit. And the lawsuit will obviously seek monetary judgment, and that monetary judgment will then attach to their credit. It will affect their credit. It can go into garnishment, whereas the judgment amount can be garnished directly from their wages. So this is a pretty serious consequence that can happen. I will say, it's not illegal to breach a contract, which is basically what happens when a purchaser fails to close. There seems to be this miscommunication where people say, oh, this is illegal. It's not illegal. It's simply just a breach of a contract. Illegal offenses usually attach with it a criminal sentence. This is not one of those situations. It's simply you fail to fulfill the contract, and the damages being the monetary damages, is what the purchaser is usually responsible for. It is a difficult process, understanding that it's difficult for all parties, including the seller slash builder. In a typical, resale property, what's happened, the seller may have debt obligations that they need to use the money to repay. The purchaser cannot fulfill the contract, so the seller is put in a tight situation as well. I work with many builders. My law firm does insolvency work. We have put many builders into bankruptcy this year, into receivership this year as well. So it is difficult on the builder as well. I have a lot of clients saying, oh, Perry, he's a multimillionaire builder. I wish that was true. It's simply no longer the case because of the amount of defaults that are happening. So you have to really understand it's difficult for both ends. It's difficult for the purchaser because the market valuations are not there. It's obviously difficult for the seller as well, simply because they have obligations, debt obligations, and monetary obligations they need to meet as well. Potential resolution options. So what's been going on with the market this year and last year as well? We've been trying to look at various potential resolution options, and the list I'm going to present you is something that I've done on many of my cases, and other lawyers have done too. I'm not sure if this is still going to be applicable going into the new year, just due to market trends. But what we have done in the past at my law firm, we've done vendor take-back mortgages directly from the builder, whether it be in first position or second position. And if it is in second position, naturally the first lender will have to allow the second mortgage to be registered. So vendor take-back mortgage, many builders were offering it. There are some that are still offering it simply because they need this property off their books. And as you all know, if the property sells at the evaluation on the APS, that will create history of the sale price, which will help the builder sell its other properties. So there's an incentive for a builder to do that. Typically, when you're in a resale situation, the seller may not be in a financial position to offer you a vendor take-back mortgage, so this may be applicable to builders only. Reduction in sale price. So we've had this issue too, where the appraiser comes in, the appraiser perhaps 50,000 short. We've had great success in explaining the situation to builders and saying, okay, here is the scenario and here is how we can close this transaction. Naturally, if you're dealing with a reseller doesn't want to go put the property back on the market, doesn't want to go through the open house process anymore, doesn't want people coming in, doesn't want to negotiate back and forth. This is an option that resellers have also entertained in the past, and builders have entertained it because they need to offload a lot of properties given the current market. There's also a potential secondary financing, which what some of my clients have used. So what they'll do is they'll get either second vendor take back mortgage. So on a resale property, as long as the first mortgagee allows it, they've gotten a vendor take back mortgage for X amount. Let's say we're doing a closing just in a couple of weeks where the sale price is 3.2 million. The appraisal did not come back for that much. And we are taking a $500,000 vendor take back mortgage from the reseller. The reseller understands the situation and says, okay, you purchased the property 6 months ago. Perhaps you might have overpaid for it, but you have a contractual obligation to me, and I'll assist you in completing that contractual obligation. So VTB again is a good option, vendor take back mortgage or second mortgage in general. I can understand and I can appreciate that there are lenders that are not going to really lend when 80% is already maxed out to the first mortgage, but it is an option that you can consider. Generally, my proposition to everybody has been beg, borrow, steal, find a way to close the deal, only because the ramifications of not closing are significant, and in some instances, maybe life-changing as well. So we'll talk about that going forward. I will give you a little bit of a story. I was involved recently in a case, is Sundial Homes Limited in Khaled. I can disclose all the details to you because the case is public knowledge. It's published on Canley as well. I had a young gentleman. He was my client. He had great success in purchasing new build properties and doing assignments of them. And unfortunately, the market turned. In this particular case, we had great resolution with the builder only because 8 months before the closing was scheduled to take place, my client, the purchaser, emailed the builder saying, hey, I cannot close. Please resell this property to another individual. So when we got in front of the judge said, well, builder, you have an obligation to mitigate your damages, meaning that if somebody is telling you 8 months ahead of time that they're not going to be able to fulfill their contractual obligations, you could have relisted and resold the property at that time. Now, the case didn't get heard all the way through. There was a resolution because the builder saw some of the weaknesses in their case. And the resolution was that we did a forfeit of the deposit. It's a $1.2 million property. He had given a $100,000 deposit at that time. We had forfeited the deposit and we signed a mutual release. It was also mainly because the appraised value, the market value at the property at the time we settled the case was approximately 800,000. So a loss of 100,000, although my client did not like it, it was something that allowed him to sleep at night because he got a mutual release and there was no more obligations on him. I also have another case pending in front of the Superior Court right now, Cherise and Morris. This is a case, and if anyone's interested, I can disclose more details. This was a purchase of a home by my individual client. And what had happened is this is not a case where the appraisal did not come back. This was a case where the buyer basically said, hey, Perry, I'm not going to close the transaction because there's a non-disclosure of a water leak in the basement, and I don't think the repairs were adequately done. The matter's before the court right now, and once we have a decision, the court date's in December, I'll share that all with you. I think it's an important case because it talks about non-disclosure. There hasn't been many cases of non-disclosure recently, but this may be something that is of interest to some of the individuals on this call today. I have listed my contact information for anyone that wants to contact me or reach me without any questions or anything like that. At this time, I will open up the floor to any questions that any individuals may have.
Okay, Barry, I have a question. Have you had any cases that the deposit was returned back to the buyer?
I've had cases where a portion of the deposit was returned, and I'll give you the authority for that. So, under the rules of civil procedure, there is a rule which says it's relief from forfeiture. So, relief from forfeiture means that, typically there is an agreement, the deposit is surrendered, but the severity of the deposit being surrendered is so severe that the judge will say, you know what, let's have a portion of it surrendered and not the entire thing. So I'll give you an example. We had a situation where $1 million property, the individual purchaser had given multiple, deposits because we had to keep extending the deal. He had $300,000 of deposits given. We were able to go in front of a judge and then subsequently make a settlement, whereas my client got back 150,000 and only 150,000 was forfeited. It's not likely that's going to happen in every single scenario, but there is discretion under a judge where a judge will say, the severity of this relief, the relief from forfeiture is sufficient for them to grant a portion of it back. I have not had any clients get the full deposit back, unless there was a mutual release exchange and both the purchaser and the vendor wanted to that relief to be sought.
Great. Many cases you see the stays, are they involved with just normal buying and resell, or I'm talking about most of the cases with the builders? What do you see in the market right now?
I'm seeing mostly cases with the builders these days. And, there was a time where the market was, I'll give you an example, in 2022, we did a case in London, Ontario. And at that time, my client had purchased the property. He had failed to close on the closing date, but was ready to close the subsequent day. And in 2022, my client's instructions were to me, they said, Barry, I don't care what you have to do, you must get me this property. And we did get him the property at the same price because there's a little error in that. Currently, what I'm seeing is people who have purchased from builders, the appraisals are just not coming in and they're just not able to close. It was a few months ago what RBC and other banks were offering. They were doing blanket appraisals. So they were saying, this condominium, every unit will say it's worth this much and we'll continue with those closings. I have seen a decline in that too now. So to answer your question, mostly builders.
All right, thank you. If there is any bankruptcy from the buyer, would that somehow help?
If there is a bankruptcy from the buyer, so basically what does bankruptcy do, right? If the buyer says, you know what, I just can't handle this financial burden, I'm bankrupt. They go to a trustee in bankruptcy. The trustee in bankruptcy comes in and says, okay, any new lawsuits against this individual are stopped, they're stayed. And any creditor, so a builder would be a creditor, for example, must fill out this paper and send it to me, and I will add you to the list of creditors. So yes, it is possible if the individual is genuinely bankrupt, yes, the lawsuit from the builder will be stayed. However, the trustee in bankruptcy will be tasked then with making a resolution with all the creditors and paying a portion of whatever resolution there is to the builder.
Great. I have a good question from Tarek. He's asking if one of the partner, let's say husband and wife, buy a property and one of them pass away, and obviously the remaining buyer cannot be qualified for mortgage. What's going to happen in that case?
So I've actually had a very similar situation to this. What had happened is the mother, so there's a mother and daughter that purchased a condo in Toronto, and it was identical situation. The mother had passed away, and the daughter's income was not sufficient to get her a mortgage. And basically, what had happened is the builder wanted to close. The builder said, that's okay, we'll put the estate on title. And we said, that's simply not possible because we simply cannot get a mortgage approval. We were in that situation, and this is the case in late 2024. We were able to negotiate a mutual release with the builder, whereby a portion of the deposit was returned, not the entire thing. And the individual young lady was able to walk away. Every case is different. Every builder is different. But typically, builders don't want bad publicity, and builders will try to work with you in a situation like that because, in addition to selling their units, they must maintain good public perception. Otherwise, a case like this makes it to the news, builder's reputation goes down, and it has, significant other issues as well. So to answer your question, if the buyer passes away and the remaining buyer is unable to qualify, if you make the correct pitch to the builder, the contractual obligations are still there because that's what the builder makes you sign. They have provisions that in the event of a death, the estate is still responsible. However, having a wholesome conversation with the builder sometimes can reach in a resolution.
These days, what is the attitude of the judges? I think there are a lot of cases coming up and they're very busy. I've heard that if a case goes from the judge for pre-construction, they said, hell with you, you sign the contract, you have to pay the builder or face the consequences. What is the general attitude of the judges or the courts these days?
So you're correct, Ashton. That is the general attitude, and the reason for that is judges and the law in general says that parties are free to contract, right? Parties are free to contract with themselves, and the law expects the parties to adhere to the contract and complete the contract. There may be other situations which prohibit the completion of the contract or impose other obligations. There was a recent case, very recent, I think it was about 2 months ago, and what had happened in that case, the builder had sued for the forfeit of the deposit plus damages. And the judge said, this individual gave you $160,000 deposit. That deposit is more than sufficient to mitigate all your damages. Builder, you don't get any more funds. I believe that case is being appealed because generally the expectation is not only do you lose the deposit, but you're also responsible for damages. But in that one particular case, the judge has held that no, the deposit was more than sufficient for both the damages and the breach of the contract.
That's good. Any questions from anyone here?
The shy audience.
Very quiet. They're all
Hi,
listening.
very
Hi, how are you?
good. How are you? It's Sirwan.
Hey, everyone.
Yeah, great presentation. I have a question for you regarding power of sale. Can you just walk us through that process and what it entails?
Yeah, of course. So I do power of sale work for both for National Bank and for private lenders as well. So the typical process, I'll talk to you about an institution. So institutions sometimes a little bit different from a private lender. Private lenders sometimes are a bit more aggressive. But typically what happens is after the mortgage goes into default, typically with a bank, and again, it's different for every case, but typically 3 months after the default, the bank takes the file and says to the lawyer, here you go, this mortgage is in default, please commence power of sale proceedings. What happens then is we typically issue a demand letter. We give the borrower 10 days to arrange their finances and pay out the loan. Now, in a good market, that may be possible. In today's market, it's typically not possible. So then the next step we do is we issue what's called a statement of claim. A statement of claim basically says, bank gave you this much money, you did this with it, and you failed to pay back the money. Very straightforward claim. Typically, what happens is there is no defense really, because what's the borrower going to say? I didn't get the money. It's not really a defense. Then we typically get default judgment following 20 days after the service of the statement of claim. Following that, a motion is done, what's called a motion for leave to issue a writ of possession. Then by that order, the judge gives basically the mortgagee, the bank or the lender, the ability to go to the sheriff and have the sheriff evict the homeowner. And then once that homeowner is out, the bank or the private lender typically gets one or two appraisals, and then they clean up the property and list it for sale.
Okay, great. And we're looking at what's the time frame for this in this typical market?
And this, so, one good thing that's going to happen now is it's going to be the holidays. And during the holidays, there's called a moratorium on evictions. So I believe this year's moratorium, and don't quote me on this, it's going to be in the third or fourth week of December where there's no evictions happening. So let's say, for example, if your client is currently in default, we are going into November. It's going to be a slower process with the holidays. So typically, once you get the statement of claim, it's a 3 to 6 month process, varying by court until the sheriff comes and proceeds with the eviction.
Okay, and then let's say if a realtor is working with a bank, for example, right, to list the property to sell it, so they basically have to wait for the court order?
So no, in Ontario, the law in Ontario, it's different from every province in Canada. The law in Ontario allows a mortgagee to have self-help remedies. So technically, if a lender wants, they could list the property for sale upon the expiration of their notice of sale. However, the court has usually held that it's a smart lender, a prudent lender is what the word they use, will go get a court order, carry out the eviction, and then list the property for sale. I'll give you a typical example. We have a lot of rental properties. The borrower has borrowed money on a rental property, and if I'm representing the private lender, we don't need to go to court. We don't need to get a court order. We simply go to the house. We do a rental adjournment. So we send our property manager in. We do a rental adjournment. We do a lock change, and we list the property for sale without a court order. And that is permittable under the law in Ontario.
Oh, good. Good to know.
Yeah,
Thank you. No, that was very helpful.
no problem.
What you just mentioned can only be initiated by the bank. I mean, there are cases that the tenants are not living. So if the owner claim like bankruptcy or whatever, only bank can send the sheriff and change the lock and send the tenant out. Is that the case? Is that what you're saying?
No, not necessarily. If the owner claims bankruptcy, the bank will still proceed with its power of sale proceeding because the bank is a secured creditor. So it wouldn't, the bankruptcy wouldn't really affect the rights of a mortgagee.
Okay.
Hi Pajot. Sorry, I could not join it on time, but like as per my understanding, I just wanted to know escape clause for my client. She had booked 3 properties, right? So last year she met with an accident, and now she is on this long-term disability, like until her this retirement, until 65 for next 10 years. She is on a long-term disability, but all the new development projects, their closing is soon, like one is in 2026 first quarter and two are in the last quarter of 2026. Will she be able to show, like to walk away any clause regarding her disability that she is not able to close? Because earlier she and her husband both were making good money, but now it's only the half income which her husband is making, and she's getting, I think, 60% of her income.
Mm. So typically, in an agreement of purchase and sale, whether it's OREA or the builder agreement, typically there is no escape clause. A change in circumstances does not permit you to escape the liability under the contract.
Mm-hmm.
However, every case is different. Perhaps, whichever law firm or whatever lawyer they're working with, they can approach the builder, they can explain the circumstances, and the builders sometimes do have the ability to work with you because this is a fundamental change in circumstances. This is not something that the buyer anticipated happening. So,
Yes.
this could be a case for relief from forfeiture, right? Relief from the contract because change of situation, change of
Mm-hmm.
circumstances. But again, every case is different. Every individual is different. Every builder is different. So it would have to be on a case by case basis. But if I've had some instances where we explained to the builder death in the family, this, that, and the other, and there is a lot of them that try to work with you because fundamentally they also have obligations they want to meet, and they will try to work with you if they can.
Yeah, definitely. Because one of my client, he has taken mutual lease from the builder, but he has taken 10% extra, but he got mutual lease because he was not able to get the closing. So he got mutual lease, but by paying 10% has been already paid, and he paid 10% more.
Yeah. And
And
that's typically what the builder will do, right? Because, and I explain to clients all the time, they say, "Oh, Perry, it's not fair." I say, "Hey, listen, the same way you have financial obligations, the builder does as well, right?"
yeah, definitely. Yeah, especially in condo buildings. Like if he has 300 units and 100 clients are ready to walk away, then what he is going to do, right?
Absolutely.
Yeah, that's true. Okay, anyways, thank you for your session. Bye.
I've seen smaller builders are more flexible to work with you rather than the big one. And I
Yeah.
heard just a case of a big builder said there's nothing, there's no VTB, there is no change of price, nothing. You close it or we go to court.
Yeah. And that's the thing. There's with the bigger builders and the larger firms, especially because that's what the big builders use, you're nothing but a number to them, right? But it is, it is beneficial when the builders and the lawyers are good, they're compassionate, they're understanding, and they try to reach a resolution. Because, as lawyers, that is really our mandate, to try and do our best for our respective clients, but to use common sense along the way as well.
I appreciate that. Thank you very much, Perry, for joining us. By the way, because every Thursday I had master classes, we are going to stop for a month of November, December. Everybody's busy, so we're going to resume the master classes. We're going to start from next year. We're going to have a lot of subject to cover there. Now, the previous master classes, they're all on my YouTube channel. You can go there and enjoy learning and listening to them. And thank you very much, Perry, for joining us. It was a great session. And if there is anyone that have any question, Perry had the number on the screen, and you can always contact him. All the best, and see you next time. Thank
Thank
you.
you guys. Take care. Bye-bye.